my dear brother Justice Ansari, my dear friend Mr. UK Chaudhary, Dr. Batra, learned councils, general councils, ladies and gentlemen. I'm thankful to Dr. Batra for inviting me here, and I'm very glad to wonderful views expressed by Mr. UK Chaudhary. It was really a great pleasure and delight to hear him. We have been hearing him in High Court, and I'm thankful to him for the appreciation he had given to me. When I was invited, I was thinking what to speak today. What gives is very interesting for the general councils who are participating here. You see, I had been heading Delhi International Arbitration Center, and then post-retirement, I am extensively involved in arbitration cases. And I find that arbitration culture is not growing in our country. So, I did a complete research on it, and also depending upon the cases which I am doing. So, first of all, in all cases which I am conducting, I have formulated a model operating procedure. I have requested Mr. Joshi to share with all of you, because otherwise it is very difficult to complete the proceeding in 1 year, and maximum time is consumed when the case goes in evidence. 8-10 hearings, cross-examination, lengthy cross-examination going on. So there in the model operating procedure, in all my cases, after the evidence is filed, I direct both the parties to serve the interrogatories on the witness. So that saves the time, and the witness has to reply the interrogatories on affidavit. After the reply has come, if the counsels find that the witness has told the truth, then there is no need for cross-examination. In 60% of the cases, counsels say that now you can straight away put the case for final arguments. Wherever they find the witness has told a lie, the right of cross-examination is still open, but now it is a limited right, because now you know to what extent he has told a lie. Now I record the cross-examination, but this cross-examination I do not record in a question-answer form. I do the complete video recording, and the procedural order says that the entire cross-examination will be video recorded and will be saved on a pen drive, which shall form part of the judicial record. The witness will sign only one paragraph statement saying that I have seen the pen drive, it contains true correction of recording of the cross-examination. In this method, I am able to record about 100 to 150 questions in 1 hour. So at times, many of the senior counsels, they said, we want 8 sessions. I said, we'll start today. And it was completed in 4 hours, 500 questions. And you are able to see the demeanor of the witness. Everything is recorded later on. Later on, a true transcript can be prepared only of the question which you want to refer in the final arguments. So this saves a substantial time. Then also the format of the final arguments. So this will share with you. And now the question arose in some of the platforms where I shared these model of procedure. They said in a ad hoc arbitration, the arbitrator may not be willing to follow it. Then how do we enforce this model procedure? Then there I have given a suggestion that in future, whenever you are executing an agreement, you can do a separate arbitration agreement executed, where you say that whenever the matter goes to the arbitration, the arbitrator will follow these model rules of procedure. So as a general counsel, you can have this, and it saves, let's say you save 10 hearings of cross-examination or 20 hearings. You save substantial amount of money. It is not only the arbitration fee, it will be mostly schedule 4, but the counsel fee is of course there. So this is one major reform which I suggest. It will be beneficial to the litigants than to the lawyers, because lawyers will be of course facing difficulty, their appearance fee will go. Then second important thing is, last year when the government put that amendment bill 2024 on the website and invited objections, so I submitted the suggestions, then also drafted, and my major suggestion was that in all jurisdictions, whether civil, criminal, labor, company, everywhere, we go on a principle that human judgment is fallible. So one appeal is provided everywhere. Arbitration is the only exception, where in 34 is not, you can't look into the error of facts, you can't look into the error of law. Therefore, does a person who has agreed to go by arbitration, Does he has given a consent that I will not even raise my objection? And word over, I have done the research, which also I have shared with you. In UK in 1969, they had a right of appeal. Not on a question of facts. They said finding of facts are final. On a substantial question of law, with the leave of the court, you can file. Then on the same model, Hong Kong also incorporated. On the same model, then Singapore also has a right of appeal. Then on the same model, then in 2002, probably, I think that year I have mentioned in my note, then in UK, they said whether this law is working well. They said it is working very well. And here, what is actually happening in courts? Today, what is happening is, and DMRC is the best example, where the award was totally against all principles. The approach of the courts at times is that not in 34. You hear a matter for argument 10 days and then say not in 34, only one line. So therefore, to my mind, and I had also advised and suggested to the government, section 34A should be there, that right of appeal on a substantial question of law of public importance with the leave of the court. So 4 rigors are good enough that every case will not fall. But now, last week, the government has put that 2025 amendment bill on record, where they have not gone by this format, although this was submitted to the government. They have framed a new provision, which I am not discussing today. We are short of time. You can look into it. But to my mind, that does not satisfy the, and it is saying that the appeal will go to the tribunal, which to my mind, as Mr. Chaudhary has rightly said, tribunalization has not succeeded in our country. Let's see all the tribunals. It is not only NCLT. You see all the tribunals. There was a judgment of the Supreme Court earlier where they had said that we should dissolve all tribunals and everything should come to the High Court. We should increase the strength of High Court. The culture of the High Court is different from the tribunals. Therefore, but once again, I see in that 2025, which also I have shared with Mr. Joshi. Mr. Joshi, you can share with everybody. And one last point I'll share with you, which again is one of the provisions which is very rarely invoked. All of you know that scope of 34 in Arbitration and Conciliation Act is very narrow. Supreme Court in the last judgment said you will not look into the errors of fact, you will not look into the errors of law. It is very, very narrow. So that front gate is very narrow. Therefore, we are saying there should be appeal. But the explanation 2, subsection 2 says that if the award is against the most basic notions of morality or justice, it can be set aside. Whereas in civil law in RFA, the judge is not supposed to look into morality. Judge can only see into legality. If anybody wants to argue on morality, the judge will say that, look, I am not supposed to look into morality. But Arbitration Act gives one wider power. Most basic notions of morality and justice. This term has been interpreted by Justice Nariman in Associate Builders to mean that which pricks the conscience of the court. So therefore means that if something pricks the conscience of the court, then the award can be set aside. So this matter came up before me, even prior to Associate Builders, I think in about 2013 or so, where I'll just briefly take 1 minute facts are very, very, very interesting facts are there, where the Kotak Mahindra Bank took a property on lease at 10 lakh rupees a month per rent for a long lease for 9 years. After 4 years, the rent fell down to half. So the bank approached the landlord in Noida that said, look, that the rents have fallen down. So either you reduce the rent to half or we'll take the adjoining property. So landlord reduced the rent to 5,50,000 by a supplementary lease deed, and the bank started paying the lower rent. After 3 years, the landlord said, give me the whole rent. They said, but we had reduced the rent. They said, no, I don't agree. So the landlord invoked the arbitration. Matter went to a retired judge of Allahabad High Court as the arbitrator. There the landlord took the plea that, look, this supplementary lease deed is unregistered and it is unenforceable. So the arbitrator rightly said it is unenforceable. When the matter came in 34 before me, I said, yes, award is legal. Arbitrator is perfectly right. Award is legal. But the award is against most basic notions of morality and justice. I said, this person had signed the document. He has made a false statement here. I should notice under 209 IPC why he should not be prosecuted, and also why the award should not be set aside on morality. After that 209 notice, the matter was settled. I could not write a judgment. But in 2021, Ganesh Benzoplast matter came before me, where again I invoked the doctrine and quoted this matter also. But other than this, I find that this, although on both these occasions, I suo moto invoke this doctrine of morality and justice, but I don't find any case law on either side or by the lawyers also to have invoked this. But it is a very important doctrine. It is a wider power given than even the civil code RFA, which even a RFA or any civil matter, even the court can't say that you can't look into morality. In fact, the lawyer have argued at times. They said, sir, you can't look into my morality. You look into the law. And if there also, if you go by law, then the landlord was right because the document is unenforceable. But if you go by morality, then it is a most immoral landlord and immoral award. So this also I have shared in my note. They will share with you. So I think this model rules of procedure, suggested amendments, which I think likely in this session they will be discussed, and also this Ganesh Benzoplast judgment, they will be useful to you. So when you go back home, you go back with some added new features. Thank you very much.